everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our content, please remember to subscribe and hit the notification bell to get notification of all of our uploads. Today's case, we're dealing with a really fun and adult one. This deals with the cheerleader and the group of college football players and their collective fun activities of consent one fateful night. This is John Doe's versus the Regents of University of Minnesota. In this case, a cheerleader decided to engage in activity with several of her friends, the football players. She then made some suggestions that this was less than consensual, but as it turned out, actually not so much. It was actually consensual. And the football players were disciplined for their wrongdoing, but they weren't wrong in the first place. So now the football players are bringing action against the university for falsely disciplining them, violating their rights under Title IX for discriminating against them because they're guys. They say because they were guys, they were adjudicated guilty, even though it turns out they didn't do anything wrong because it was all mutually agreeable the whole time. So let's learn about the cheerleader and the football players from the University of Minnesota. Let's get started with this. In the early morning of September the 2nd of 2016, 5 university football players, including John Doe's 1, 2, 4, and 5, and a recruit, engaged in mutually acceptable fun times with Jane, a university cheerleader. The next day, Jane and her mother told Minneapolis police these men had assaulted her, but please take note, the Court of Appeals says consensual. So, despite claims of hashtag believe all women, not so much. This university cheerleader just decided to have a fun day on the 2nd and maybe has some regrets, and now the students are being punished and they want to sue them because of the sexual discrimination. So let's learn some more. During the investigation, the Minneapolis Police Department informed the university athletic director that Jane had accused 4 players of assault, which prompted the university to suspend the players because of optics. All right. The suspension was later lifted after the Hennepin County attorney received the investigation findings and declined to file charges because, it turned out they were consensual. The Jane's allegations came to the attention of the Title IX office, the campus department tasked with investigation complaint of misconduct. The Title IX office opened an investigation. Jane met with the assistant director, Tina Marziam, the investigator. Marziam investigated complaints of misconduct made against football players in 2015 and concluded the failure to corroborate those allegations was made up by a team member. During the initial interview, Jane presented a more detailed version of the events on the 2nd than she had provided the police. So please take note that she has reported this to the police. The police have investigated, conducted an investigation, and the prosecutor says, I can't bring these charges because not so much. But that's okay, because even though a police department with actual detectives looked into it, we've got Title IX officer on the case. And Title IX officer is going to conduct an even better investigation than all those professionals who went to police academies and all the rest of it. So she's on the case. I feel better already. So Jane presents a more detailed event to her. Why didn't she present it to the officers? One might wonder, but apparently Marizam never asked that question. And then she provides a more concrete description of how the events, including the assaults from John Doe's 1 through 5 occurred. This interview led them to investigate John Doe's 6 through 11, who were in the apartment when the assault occurred. Jane participated in 6 interviews with Marizam, who permitted Jane to refine or revise or modify or augment or, her accusations in response to Doe's individual statements. So as every single one of these guys is interviewed and giving a statement, Marizam is saying, hey, Jane, you want to revise what you said in light of what they said. And Marizam only allowed Jane to review a draft narrative for accuracy, making sure that On October the 11th, 2016, Marizam, Title IX officer over here, sent emails to John Doe's 7 through 10, requesting they come in for interviews. They did not disclose that they were the targets of an investigation in misconduct. Yeah, it wasn't just John Doe's 1, 2, 4, and 5 that had a relationship with this woman that night. According to the statement that she told the investigators, she was unsure of how many adult activities with how many people she had that day. It might have been 10, she said. It might have been 20. She wasn't 100% sure. So, yeah. Marizam did not record the statements, allow them to review or respond to the statements or statements from other witnesses, or allow them to confirm the accuracy of the summary of their statements. At the office's behest, the athletic department warned those that their scholarships were at risk if they didn't cooperate. So Title IX went over to the athletic department and said, put pressure on them. And the athletic department said, if you don't cooperate, we're going to take away your scholarships. Fun. Marizam, Title IX officer to the stars over here, summarized her findings in a report, which they submitted to the Students' Conduct and Academic Integrity Unit. The report recommended expelling John Does 1 through 5 for sexually assaulting or harassing Jane, suspending John Does 7, 8, 10, 11 for 1 year for harassment, and placing John Doe 9 on probation for providing false statements. And John Doe number 6 apparently didn't do anything wrong, even according to the Title IX office, so okay. After receiving this report, the president of the university ordered the suspension of John Does 1 through 5 and 7 through 11 from the football team, preventing them from participating in a bowl game. The president released a public statement regarding the suspension, assuring the public they were based on facts, and the university values and serve the goal of ensuring a safe climate for female students. Reacting to the suspension, the football team boycotted the bowl game to protest the perceived lack of due process. The boycott prompted criticism for all corners, some supporting the football players and some supporting the cheerleader. So save the cheerleader, save the world has gone very, very wrong at the University of Minnesota. So yeah, the football players have been suspended from the bowl. The football team is boycotting the bowl because of due process. Now there's a whole eruption on campus because of the whole thing. The whole thing has gone completely great. So that's just wonderful. The university is just doing stellar work over here. So let's read a little bit more. In response, Kohler, and the university met with the team members. The university president, this might be my favorite part, offered to lift the suspensions of John Does 7 through 11 if they admitted to the accuracy. So maybe to save face, maybe otherwise, maybe a plea deal, I don't know. But the university said, hey, John Does 7 through 11, I'll lift your suspensions as long as you admit that they're accurate. The players said no. And the team just ended its boycott based on assurances that they'd receive a fair hearing. Several weeks later, the president issued statements to the Tribune, declaring that there's no due process associated with athletic suspensions. So we don't need that due process. The university increased sexual harassment training didn't seem to make the point with the Does. The alleged complaint, this would be the complaint from the football players, alleges that the statements fostered a lynch mob mentality towards the Does and contributed to a campus of suspicion and hostility towards African-American males. So fantastic. We have turned wokeness into a race war. So that's super, super fun. And we've declared that due process is not a thing. Excellent. Let's press on. The amended complaint from the students alleges that Title IX office report contains several troubling features. The report found Jane more credible by emphasizing minor inconsistencies in Doe's statements, while minimizing or ignoring her inconsistent statement. So they're willing to overlook her more blatant statements as they looked for every little error or problem in their statements. It didn't recommend punishing Jane for having a consensual relationship with an underage recruit. So apparently as part of their investigation, Jane, who I believe was 22 at the time, had a relationship with someone who underage, which I don't know if that's in violation of law or not, but didn't recommend punishing her, or for falsely accusing John Doe 6 of misdeeds. It attributes statements to John Doe 11, which he alleges he never made. Finally, the report criticizes the Doe's purported attempts to conceal evidence while neglecting to mention that Jane withheld evidence, including results from her assault examination with the police and the video of her, John Doe 1, and the recruit engaging in adult time. There's a video. There's a video of them engaging in this time together that she withheld from the investigation. Super fun. Dissatisfied with the report's conclusion and sanctions, the Does invoked the university's due process protections for students accused of misconduct and requested a hearing before the Student Sexual Misconduct Subcommittee. After a hearing, the panel concluded that players 1 through 5 who admitted to having relationships did assault or harass Jane. There was insufficient evidence of 7 through 9 and 11 committing misconduct, and that 10 harassed Jane. The players found guilty of this appealed to the university provost, who affirmed the filings as to 1 through 5, but reversed the harassment against 10. There are no further appeals within the university or Minnesota Court of Appeals system with respect to that. So that's how all that one wonderful thing went. And now we want to go to federal court and complain about the Title IX violation for sexual discrimination because you treated us worse because we're guys. So let's do that. Here's the relevant law. Title IX. It's very, very short, actually. It's extremely short for a law that has this impact. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits in, or subjected to discrimination under any educational program or activity receiving federal financial assistance, which is pretty much all of them. So this applies to both sexes, either one. You can discriminate against men. It's possible. That's the way the law is written. Amazingly, it's neutral. So yeah, that's the relevant law. It can't discriminate against anyone. To state a claim, the plaintiff must adequately allege the university disciplined them on the basis of sex because they're male. So whatever else is true, whatever else might be true in terms of due process violations or whatever, you have to say it's because you're male as opposed to some other reason, or whatever else it's not a Title IX claim, okay? All right, so now that we understand the operative factual pattern, including the videotapes, including the recruit, including all kinds of times, including, this cheerleader's interesting activities days, we must now decide how we are to evaluate this discrimination claim. So were the football players discriminated against because they're male? How shall we evaluate that? Let's look to the relevant case law in order to decide. As in a prior case from the University of Arkansas, Fayetteville, we conclude that the Doe's lengthy amended complaint alleges a number of circumstances which, when taken together, are sufficient to support a plausible claim the university is discriminated on the basis of sex. In reaching these conclusions, we of course assume that all the allegations given by the plaintiffs are true and draw all inferences. So, as always, for the purposes of determining plausibility, we're going to just look at their complaint, right? First, the Does allege the university was biased against them because of external pressures from the campus and federal government over perceived lack of diligence in investigating and expelling students. The Does allege that in response to the boycott, various groups on campus urged officials to take a tougher stance against misconduct when pressured by officials to corroborate Jane's accusations. Is it possible to leave space open to believe a party stories and leave open to believe our party story? Oh, surely, of course. Surely, of course. Yeah. You can believe, especially, just put yourself in the position that I'll just give you the instruction a judge will give you if you were a juror. You can believe people's testimony in whole or part. It's up to you to believe what you believe and what you don't believe. So you can believe testimony in whole or part. You can, if someone's lying about one thing, you can conclude they're lying about other things or not. It's up to you. So can you believe both people's stories? Sure. I mean, there's obviously going to come a point of conflict when you can't believe them both, but yeah, sure, you can believe them both, at least in part. Why not? Additional pressure came from past criticism of the president and university for inept response for former sexual harassment of multiple staff members. The players contend that these pressures influenced the university in this case to infer that the players should be suspended initially because of the optics rather than because of any actual evidence in the case. In the University of Arkansas, Fayetteville, we've concluded that allegations of a dubious decision in misconduct proceedings at issue, taken against the backdrop of substantial pressure on the university to demonstrate its responses to female complaints, were sufficient to state a discrimination claim under Title IX. Here, the external pressures were, if anything, greater, and the detailed allegations of investigator bias and dubious procedures in these proceedings lend credence to the inference of discrimination on the basis of sex. Considering as we must the totality of the allegations, we conclude that Doe's state a claim the university discriminated against them on the basis of sex in the misconduct and disciplinary proceedings. Thus, that brings us to the end of the case of John Doe's versus Regents of University of Minnesota. In this case, the University of Minnesota is a fun, happy place where the students engage in collective co-ed activities. These co-ed activities include social events in which the cheerleaders associate, or at least a cheerleader associates with Apparently the entire football team, to be quite honest. And there appears to have been some regret around this, and she made some stuff, and the football players are not happy. So they're suing because the university discriminated against them because male, because the witch hunt and the mobs and all the rest of it, and the lawsuit can definitely go forward. So will we see testimony from any of them? Will we see testimony from Jane Doe? Will we get a copy of the video apparently involving Jane with player one and the recruiter, whatever? I don't know. But until later, my friends, this is all. Cheers and goodbye. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.